Hello and welcome to the Emerging Litigation Podcast. I'm your host, Tom Hagy. Today we're going to talk about an evolving twist in employment law. You might even call it emerging. And that is the concept of reverse discrimination. Maybe not a perfect phrase, but it's a phrase. Nonetheless, those are words. And I am over the moon to have back today's guest, Leah Stiegler. She's back on the pod, which is what the kids call these productions. So see, you're already learning something. And I think they like it because it's short and punchy. I've been described that way as well. Leah is an attorney at Woods Rogers, where she focuses on employment law and workplace litigation. She advises organizations on compliance with evolving federal and state regulations. She has a reputation. Don't laugh at yourself when you talk, Tom. She's got a reputation for tackling complex issues in discrimination, DEI initiatives, those are popular, and emerging workplace trends. Leah brings both extensive legal experience and a practical approach to helping employers navigate today's challenging legal environment. She's successfully represented clients before state and federal courts and is a frequent speaker and author on topics ranging from Title VII litigation to the impact of technology on HR practices. I should mention first that Leah was slightly late in joining me, which I'm never late, because she was traveling from a conference where she was speaking on employment law. And when she left, she was greeted with a rainstorm, and so that set her back a little. Now, I offered to reschedule, but her answer was something like, "Why would I do that?" Those are my words. That's how I took it anyway. So that demonstrates to me she's not only an excellent attorney, but she's an excellent sport. So with that, here is my interview with Leah Stiegler of Woods Rogers. I hope you enjoy it. Well, Leah Stiegler, thank you very much for coming back to the Emerging Litigation Podcast.
Thank you for having me, Tom.
The one thing. Oh, by the way, Stiegler. You know what Stiegler? Do you know what it means?
Strong woman. I have no idea.
That's what it should mean.
Yeah.
I can't. I was going to try some German, but I don't know any. No, I looked it up because I'm always curious about names. Apparently, it's named after maybe your family lived near a gate or a ladder. So, like, it comes from Stiegel.
Oh, interesting.
Yeah. So,
well, I found out that my first name, Leah, that one context of what that means, I was ordering kebabs, and the host explained to me that where he's from, the name Leah means grassy field. So I am the gated grassy field.
There you go. And my last name means hedge. So I could be on the edge. Okay.
You could be on the edge of my field.
Of the field, right. So our families could see each other. So yeah, we're going to talk now about, I say it in the introduction, about reverse discrimination, for lack of a better phrase. So there was a Supreme Court decision that we're going to talk about called Ames. I can just read off my brief kind of summary of what it is, and then you can get into the details.
Sounds good.
So, Supreme Court decision, it's Ames versus Ohio Department of Youth Services. It addresses critical issues under Title VII of the Civil Rights Act of 1964, and I was 7, particularly the evidentiary standards for proving disparate treatment claims. The court unanimously rejected the Sixth Circuit's, quote, background circumstances rule, which imposed a heightened evidentiary burden on majority group plaintiffs, like heterosexual individuals or white individuals. It reinforces the principle that Title VII protects all individuals equally, regardless of their membership in a majority or minority group. Am I accurate so far? Okay. So let's talk then about that case. So equal standards for all plaintiffs under Title VII?
This is an interesting case, and it made its way all the way up to the highest court, the Supreme Court. You use the term reverse discrimination, and my lawyer colleagues will tell you there's no such thing as reverse discrimination. It's just discrimination. But the media has captured that term, reverse discrimination, and I think it plays well in terms of understanding this Ames case, because in this Ames case, you had a white heterosexual female bringing a claim, and by nature of the fact that being a heterosexual white female, she was in the majority. And so the idea of reverse discrimination is somebody from the majority claiming discrimination, in terms of it's the reverse of what we would normally see, or the reverse of maybe what the Civil Rights Act was initially passed, what Congress intended to protect back in 1964.
Yeah. Okay. So it rejected the background circumstances rule.
The lower court basically said, well, Ames, if you're trying to prove that you were discriminated against in the workplace, then you have to prove a heightened standard. Because you're in the majority, you don't just have to prove the typical framework that a plaintiff would have to prove. You have to also show that there are some sort of background circumstances about this employer that would give you the implication that they are discriminating against you. So in a typical employment case, when I say typical, take that with a grain of salt. Let's just say you had a Black male suing for discrimination. That lower court would have said that that plaintiff would have to prove that, they were qualified for the position, they applied for a position, didn't get the position, or that they were terminated because of, or that their race was in part a motivating factor for the termination or for them not getting this particular position. Well, they imposed a higher threshold on this plaintiff, saying, well, you also have to show some sort of background circumstances. And what those background circumstances are could be potentially statistical evidence about the employer. Maybe everyone in leadership is, of a particular race. And in the Ames case, one thing that came up was one of the claims that she made was about sexual orientation discrimination, and making the argument that there was a fact about the supervisor being homosexual, that traits about that supervisor would be some background circumstances to lead to this idea that that supervisor was biased against her because she was heterosexual. So you've got to, the lower court said, you've got to jump to prove a higher threshold or meet a higher threshold. The Supreme Court of the United States on appeal said, no. We're not going to oppose different or put in place different standards for different people. That discrimination is discrimination. And when you read Title VII, it says we protect people in the workplace on the basis of sex, gender, race, religion, national origin. It doesn't say that because you're in one group or another group, you have a different standard.
Gotcha. Okay. And then, go ahead. I'm sorry, Leah.
One thing I was going to ask you is this idea too of what is the majority, because I think that proves harder and harder every day to make the argument of whether a particular person is in the majority, maybe even geographically or something.
Yeah, I think that's, because the nation is increasingly, I don't know if is it the Hispanic population or just non-white population is going to be in the majority. But I guess then they'll probably, I don't know who I'm talking about, but at some point then you're going to want to say, well, there are more of them, but are they in positions of power? I don't know.
It's hard to define that majority thing. And I think you're exactly right. If I recall the 2020 census statistics that came out, it said the results were that the under 18 population in the United States, that a majority of individuals under 18 identified as biracial or more than one race.
Yeah.
So to your point, over time, does what we're calling the majority today, does that change? Then even can you look at it on a geographical basis? So I think the lower court and other circuit courts had imposed this same background circumstances test. I think that the lower court did get it wrong by reading into Title VII something that wasn't there, a standard that wasn't there. And I think it's a difficult standard. It becomes very unworkable as we move along.
Yeah. Yeah, your point about geography too. If you look at Washington, D.C., is it 70% or at least 70% African American or Black? I'm still catching up on my own terms. It's at least 70% Black, maybe 90. I could be exaggerating. I'll check that, but but yeah, that's the majority.
Yeah.
But
well, one thing that's interesting about, I think the idea of reverse discrimination becomes a really hot button political topic for sure, because you see it in the context of diversity initiatives as well in the workplace and a lot of lawsuits moving forward. And I can tell you about one in particular. But on the geographic note, my law firm, some of my colleagues and I, we did a mock trial based on the Ames case. So slightly different, but pretty much the exact same facts, just more narrowed. And we did that in two different jurisdictions. First, we did it in Lynchburg, Virginia, which is a red city.
Very conservative. It's as you said earlier, it's where Liberty University is. Right.
Liberty University is very religious, very red city. We also did this exact same mock trial in Richmond, Virginia, which is a historically blue voting city. And based on the same facts, in Lynchburg, Virginia, the jury that we paneled, they were members of the public. They found for the plaintiff, for the white male plaintiff in our facts and awarded him $600,000.
Mm-hmm.
In Richmond, the Richmond jury found for the defense, giving the plaintiff nothing, and found that there was no discrimination. The same set of facts with two very different results. And I think a lot of that is geographical.
Absolutely. The politics has to come into play as well. But so in that case, in your mock, do you remember what kind of the background? I'm just curious. What was the background of the person doing the firing?
Yes.
Or whatever.
We used sexual orientation was at play. So we used the supervisor was
Same thing.
a gay male and had terminated a gay male a plaintiff. And in the Ames case, the actual case caption is Ames versus Ohio Department of Youth Services. In this case, we used a made-up department, the Virginia Department of Youth Services. And so we used sexual orientation. And then we also added a race factor as well, that the plaintiff was later replaced with a younger Black female. So a little bit of a caveat there. But we wanted to add that race component as well, because you see a lot of talk in the news about diversity programs. You see executive orders trying to rein back diversity and talk about what's unlawful diversity. And so on this idea of race discrimination, there was a case out of and reverse discrimination. There was a case out of North Carolina, Duval versus Novant Health. And in that case, you had a white male plaintiff who was a senior VP of marketing for Novant Health. And Novant Health had put in place sometime in like 2016, they had signed on to basically this idea, this equity program where they were going to try to have more diversity in their leadership. They were going to have 4 years of trying to work towards these goals, and then executive bonuses would be tied towards meeting, in part towards meeting these diversity goals. Well, this white male plaintiff, who was the senior VP of marketing, had a great stellar performance record, yet was terminated and replaced, and his duties were initially given to a Black female and a white female, and then he was later fully replaced by a Black female. And so his argument was that he was the victim of reverse discrimination, or we'll just call it discrimination.
Right.
That's what us lawyers would like to call it. So that he was the victim by way of the bias against him because of the company's diversity program.
Mm-hmm.
The jury awarded him $13 million, saying that yes, race and gender were motivating factors in the termination decision.
Okay. Wow. I remember as a very young guy, when I came to Philly from Ohio, and I was trying to get a job, any job, and all the jobs opening, they were all in sales. Everybody wanted salespeople, and I wasn't a salesperson. And I was like, all right, but I'll try it for a while. And I came with a little bit of sales experience from a newspaper. And I went to a paper. By the way, I'm a white male Christian, or not a Christian, but I was raised in the Christian, whatever. I'm not really anything, but that would be my bio, I guess. I was raised Presbyterian, but mostly
yeah. You said you got boxes. You're checking on your EEOC complaint.
Right. Exactly. You're exactly right. I'm planning ahead. I mean, even though in church, mostly I doodled just to stay out of trouble. But no, I went to a newspaper called the Jewish Exponent in Philly. And I know it was pretty widely read. And I thought, well, this will be cool. You know, it's a niche market and I can do that. And I said my name, Hagy, and I had the interview and somebody kept coming out and asking me my last name. And could you spell it? I'm like, Hagy, Hagy. I'm not sure I even got the interview. Now, I'm not saying they discriminated against me. It's too distant the memory.
So your last name wasn't Jewish enough, is what you're.
That was. I wasn't. I was too naive to think about that at the time, and I was like, I don't. Why they want to know my last name? And then it occurred to me later, maybe, and in that case, it's a Jewish newspaper, so maybe you would expect Jewish people to be selling. I don't know, which was all fine, and maybe you can tell me whether I should go back and. I'm sure the statute has run.
Yeah, about the statute of limitations has probably run out on that one, Tom.
Yeah.
But what's interesting about the idea, bringing up the concept of you identifying yourself as a white male Christian,
right,
is that, every single person in the workplace or that's applying for a job is protected by Title VII. Every single person has a race, a color, a religion or not, or a belief system, a sexual orientation, so a national origin. So every single person is covered. I think there's too often a misunderstanding that, Title VII is only there to protect women and people of color, but that's not the case. That's been the primary need for it, in my personal view, over all these years. But I think there's also this concept that we're seeing emerging a lot in the law called intersectional discrimination. Are you familiar with this term?
No.
It's the idea of,
Like I'm half Italian and a drummer.
and a drummer. I'm not sure being a drummer
That tends
is a protected
well,
class.
there's a lot of stereotypes.
About Italian drummers?
Just about both of those. I don't know if
Okay.
in a crossover, it's an intersectional thing.
Okay, well, so to actually meet the prong, you would have to have two protected classes, and there would have to be a stereotype about being that comes from both of those protected classes. So maybe a stereotype about Jewish men, or a stereotype about Black women. And I had a case that dealt with a situation where a Black female claimed this. Not only did she claim race discrimination and gender discrimination, but she claimed that because she is a Black woman, that the company imposed this bias against her, that she was an quote angry Black woman, and so there was a bias that by the fact that she was both of those protected classes, that's where the bias came into play, and that Black men were treated better than her, and that white women were treated better than her. And so it kind of opens up this door. And so I don't know, you can think about something like, someone's religion and their national origin. So someone who's maybe Islamic and from the Middle East, maybe there's a bias as to their belief system or the way they would interact with women in the workplace or something like that.
Sure. Gotcha. Yeah. Sorry. I was going to ask you something. COVID fog is a real thing, by the way. COVID brain fog.
Well, so you could fall under, if you've got, like, let's say you had long COVID or something, you could be the disabled, you could have the disability protected status and be that Italian drummer. So you're really intersectional right now.
What a niche.
Right. And I hope your listeners don't take this that we are saying one side or another or something like
Of course
that,
not.
because I think the goal for all, what's interesting about these kind of emerging issues like intersectional discrimination and like the concept of reverse discrimination is, Congress passed the Civil Rights Act in 1964. I don't think at the time that they passed the Civil Rights Act, they ever thought, for instance, gender identity or sexual orientation would be protections. But we read that word sex in Title VII to encompass both of those concepts.
Mm-hmm.
And then you also see lawyers, pushing these cases even with the idea of reverse discrimination. I bet if you interviewed some of the congressmen back then, that they would say, we were coming out of segregation, and the whole point of this was to give people of color the opportunity in the workplace. We never meant for this law to protect someone who is a white heterosexual male, stereotypical employee who hasn't historically faced adversity in the workplace.
Right. But it's interesting, though, to your point, it's to protect all groups, all people, not just groups. And I guess that was the point. I guess the point, too, the case talked about the McDonnell-Douglas burden shifting. Is that worth talking about? Let's see. It was a framework for evaluating disparate claims, but emphasized the prima facie burden is not onerous.
Sure.
And then
yes.
Talk about that.
So the McDonnell-Douglas burden shifting framework, this in federal court, to prove that you were discriminated against on the basis of or under Title VII, the court looks at this burden shifting framework. And so if I'm the plaintiff and I'm saying I'm suing for discrimination on the basis of my gender, let's say I'm saying I missed out on this promotion because of my gender. The position was given to a male employee that was less qualified. To meet that prima facie case, I have to it's a low burden, it's a low kind of threshold, and I basically have to prove that I was qualified for the position, which can be as easy as I was in this position for 4 years, or here's what the position required, and I had all these qualifications, right? And that I am a woman, and that I did not get the position, and a male employee did, or I was terminated and a male employee took my spot. So you can't meet that prima facie case if, for instance, you're saying my company terminated me and discriminated against me because I'm a woman, if the company replaced your position with another woman, right? Because clearly then there's no, the company didn't make its decision based on your gender if they went ahead and just replaced you with another woman.
Mm-hmm.
So that initial prima facie case is a pretty low standard to meet. Once I meet that, then the burden shifts to the employer, and the employer gets one shot, one chance to say that no, we didn't terminate you or we didn't not promote you because of your gender. It was because of your performance or you engaged in misconduct. So they have a burden to prove, they have a burden of production, to produce evidence to show that they had a legitimate business, a non-discriminatory business reason to take that adverse action, to either terminate you, demote you, not promote you, you name it. That's not the end of the story though. Under the McDonnell-Douglas framework, once the employer meets their burden, the burden shifts back to the employee who gets the final say. And the employee gets to look at the employer and say, liar, this employer is lying. And here's how. They're saying it's about my performance, but every year my performance reviews show I walk on water and exceed expectations. Or they say it's about performance, but they don't actually have any documentation. This is just a made up after the fact excuse to cover up for unlawful discrimination. Or they can point to something like statistics. Or my favorite is they can point to something that someone says during the termination or around the termination that would give you the inference that their decision was discriminatory. I have a case right now where the plaintiff is claiming that 2 days before she was terminated, she was at a retirement party for another employee, and her supervisor asked her, well, aren't you thinking about retiring soon? Close in time comment is what led her to believe that the 2 days later, her termination was based on her age. So that's sort of the burden shifting framework that a typical employer would have to be mindful of.
My general advice to managers is talk less. Aren't you about to retire? When are you pregnant? It's just like, what else are we going to, how else can we step in it? I say we, not as me. What?
I said, you'd be amazed what I always had the impression when I was younger that if you were a manager, I just kind of stereotyped you that you knew what you were doing. And now that I've spent the last 10 years in private practice advising employers, I very well can tell you many managers have absolutely no idea what they're doing.
I promise you, they do not. And I was one of those. I mean, sometimes you were just there first.
Right.
And
you were the longest serving employee and the spot was empty and they put you in it. So
yeah. Yeah.
Or maybe, hey, because you were a white Christian male. Who knows how? I will say I had a client reach out recently. They had a manager who, owner of the company, was asking managers to sign on to a faith statement. And this was a retail store, zero affiliation with religion. The store itself. Like imagine just selling clothes and products and goods. And if you wanted to be a manager there, you had to sign on that you were going to agree to this statement of faith, which even included an initial area next to a paragraph that said that you believe that marriage should be between a biological man and a biological woman. And I was like, what does this have? This has nothing, like selling these t-shirts has nothing to do with
mm-hmm.
And I was like, I am just amazed that this owner has made it this far running this long-standing store, but maybe because the owner has been just hiring people that he knows or people from church or something that hasn't really come out and about to the public's eye. So
wow. Okay.
Yeah.
All right. I know. Okay, that's wild. Let's see. So I talked to your, because DEI, we mentioned it, and I talked to your colleague, Patisse Holland.
Oh, I love Patisse.
Yes. She was delightful. She was great on the podcast. And we talked about DEI, and just because it's kind of fallen out of favor, these are my words, with, I don't know how else to say it, with Republicans. I don't know how else to say it. I really don't. But it's criticized by a huge segment of the country.
Yeah.
And it doesn't mean that the reverse is true now, that you don't have diversity, and she was very careful about, well, here's what employers need to do, to keep this going. You're you're not supposed to discriminate anyway. So there are laws in place, but it was interesting. I don't know if you have anything else to say. I think part of it was from Justice Thomas. He wrote a concurring opinion in the Ames case. Wait, Ames case? Ames, yes. He expressed concerns about DEI and that they may inadvertently discriminate against majority group employees. So anyway, that's where some of that maybe is coming from.
It is. I think one of our other colleagues, James Wimmer, he used, I can't remember exactly the term, but it was something like this idea of DEI fatigue or the fear, people having there's more of a fear about DEI than truly a desire to understand what's lawful, what's unlawful. So yeah, no, I think, what's always, generally my take is what's always been unlawful is still unlawful. You could have never before discriminated on the basis of someone's race, regardless of their gender or race or sexual orientation or whatnot. But that it's, there's more of a fear that people are misconstruing this idea of DEI with meaning that companies are putting in place quotas and engaging in sort of affirmative action, all of which have already been unlawful for many forever.
I mean, I'll say it. You don't have to say it, and I'm not even going to ask you. But it's just a political thing. It's just like this is going to get people. This is going to get people riled up.
Right.
You know what I mean?
Right. What's true? What's not true? I mean, I don't know. I was saying last night, I was like, why do we even watch the news or read the news anymore? Because you cannot figure out what is real. Like, at least with statutes and what's in law, there's some concrete basis that I can go pull up what is in the Federal Register. You know what I mean? I can pull up a statute and I can try to interpret it. I can pull up a case and I can try to interpret it. But news articles, to me today, it is like just even trying to understand if you're following the Charlie Kirk situation, like there's all this talk out there about whether or not he was in a relationship with a transitioning roommate, whether that was part of it. And I haven't seen any like evidence or proof of this. And I'm like, maybe this all just started because someone wrote a news article on the far right to try to create fear that, someone who's transgender is the core source of this violence or something. Right. I can't find any evidence to support that. I don't, mean, so it's wild. Yeah. Everything out there is so political now.
Yeah. And it seems like whatever good intentions, it's turned around, it's like, we want diversity, and it's the way it's pitched is, well, they're going to hire a minority even if they're less qualified. And people buy that, and that's sad. Okay, so moving from that though, you mentioned, well, you represent employers and you advise employers and you even do training. So how does this affect training? If you're going to train somebody on sensitivity, are they going to say you're being insensitive to them because you're making me sensitive? Talk about training and how this might affect them.
Everybody is sensitive now.
Yes, I'm very sensitive.
Well, yeah, everyone's got their own subjective belief. Absolutely. I can't emphasize enough that companies need to be still conducting anti-discrimination and anti-harassment training. Many companies are pulling back on their training. When I say DEI training, that could mean anything from, training on civility in the workplace to implicit bias terms to pronoun and usage, anything around training about microaggressions, you name it. And so many employers are hesitant to move forward with that, mainly because I'd say you could have that one special employee in the audience who's going to make an issue of it, who's going to refuse to attend the training, or who's going to say, my desire to not attend this training is protected activity. And if you terminate me for it, I'm going to sue you for retaliation under Title VII. We have seen lawsuits where an employee has refused to go to a company-sponsored training and the company made as a condition of their employment, and they were terminated. And that person is saying that, no, my desire to say, no, I'm not going to support what you're preaching is protected activity. I emphasize to clients, no, you move forward with your anti-discrimination and anti-harassment trainings. Those that these laws are very well in place and strong, whether they're state, whether they're federal, or both, and that it's your decision as an employer to make sure that your workplace culture is respectful of biases and harassment and treatment like that.
Right. Like you said, it was always illegal to do those things. It still is. Now you mentioned the T-shirt company with the sign off on religious beliefs. So recently, on July 28th, there was an executive order from the Trump administration. The directive was titled. You brought this to my attention. Was titled "Protecting Religious Expression in the Federal Workplace." Significantly expands the rights of federal employees to express their religious beliefs at work. And the guidance was rooted in two executive orders, 14202, eradicating anti-Christian bias and establishment of the Religious Liberty Commission.
Yeah.
So that sounds fun. So tell me about that. What impact do you think that's going to have? Now, this is for public employees.
Yeah. This is an executive order directed at federal agencies, but I do think it shows you the landscape of what, let's say, the EEOC, the federal agency that enforces the Civil Rights Act, the approach that they're going to be taking as well in the workplace is sort of an emphasis on religious rights in the workplace, and an emphasis on bringing cases that fall under this category of reverse discrimination, maybe, or anti-Christian bias, you name it, and less of a priority on the LGBTQ charges or race discrimination charges, or pregnant worker charges. So yeah, basically this executive order said it's okay to do a little proselytizing in the workplace. You can have respectful conversations, trying to talk about your religious beliefs and convince others about your religious beliefs. I don't think that changes anything substantively. I think that has probably always been somewhat fair game. Now, you can't get to a point where it becomes unlawful harassment. And the definition of harassment is unwelcome and offensive conduct that's severe or pervasive in the workplace, and that's based on something like religion. And so if I start telling you about my religious beliefs and I'm trying to get you to go to church with me, Tom, and you say, Leah, look, I'm good about this. I really don't want to talk about this anymore. And I keep pushing it. I've just hit that unwelcome standard, right? You've made it very clear to me as your coworker that this discussion is unwelcome. And then from an offensive standpoint, the courts look at that on two prongs. They look at what's subjectively offensive. So we were just saying that you're an extremely sensitive person, Tom. So you might have, exactly, a different level of sensitivity than I would, for instance. But they also impose an objective prong to that offensive standard. So what is objectively offensive to a reasonable person? So in this context, I'll give you the example of somebody who is so vocal about their religious beliefs in the workplace that they hit those standards by maybe saying something offensive about women who get abortions, right? And that is offensive to other women in the workplace and potentially that reasonable person standard. Or they talk about, someone going so far as to say something so egregious as, Islam, that's a terrorist organization, or something so ignorant like that. That would hit that severe or pervasive, unwelcome, and offensive conduct. So what I don't like about this executive order is it probably doesn't do anything to change law, but it just puts confusion out there that lets people say, oh yeah, so we can proselytize at work now and you can't do anything about it. Just like this idea of diversity is unlawful. Okay, well, what does that even mean, right? And the previous executive order didn't even define that. So I don't know. I mean, do you really think how often do you think it comes up that people are proselytizing in the workplace?
I never heard it in my many years in an office. I'd never heard it.
Even when you applied to, as a Christian man, to work with newspaper, they didn't try to at least convert you?
They did not. They did not. But, after living in Philly, after a while, I realized that there was a point when I think at least half of my friends were Jewish. And I was dubbed an honorary Jew by them.
Right.
So I think I could have gone back with a little bit more street cred, but no. So, sales wasn't my thing.
I was talking to my dad about it. My dad is from Boston, and he grew up and was raised very Catholic, went to Catholic school, Boston Catholic. And he was explaining that even in a lot of the neighborhoods up there that, you had the South Boston and this side of the railroad tracks.
Right.
The Italian community,
sure,
Portuguese community, all this stuff. And that, it wasn't just about national origin in terms of if you want, like my dad wanted to go work at a particular liquor store. Well, no. that's not the Catholic liquor store. You got to go
Right.
across these railroad tracks to go work
Right.
this liquor store. So, I think, and that's just kind of overt discrimination in terms of who can work here, like your experience applying for a job.
Right. Yeah.
But I think more and more employers are seeing a diverse workforce with employees with diverse belief systems. And the law doesn't protect an employee's belief to a particular denomination. The law just says that we protect employees' sincerely held beliefs. So even atheism, if it's a sincerely held belief, can be, your belief system, and talking about that in the workplace, that there's some level of protection. The same with if you believe in the Church of the Flying Spaghetti Monster, which is in fact a real.
No.
Yes, it is.
I will be looking that up.
You could Google it. I was doing a presentation, a management training one time, and the manager was like, we had an employee who actually had the Flying Spaghetti Monster tattooed on his arm.
Wow.
Yeah, it started as, my understanding is that it started as sort of this online belief system where the god was like interwoven spaghetti with two meatballs as the eyes.
Sure.
And then they had like a whole thing of commandments and kind of like tenets of this Church of the Flying Spaghetti Monster. And it started as this idea that, look, if you can believe in someone who walks on water, or who someone could part the Red Sea or something like that, then why can't you believe in this flying spaghetti monster? And so here, if you can believe in this sort of mythical like effort, then you can believe in this mythical effort. And now it's expanded, and there actually are kind of even like denomination branches.
Oh my gosh.
But an employer is not supposed to, push back too much on what the employee's actual sincerely held beliefs are, because two employees can go to the same church and still have a different belief system.
Yeah.
Your beliefs are independent to you. So I always tell employers, don't focus so much on pushing back on, that's not really what this denomination believes, or like, why would you be doing that if you're Jewish? That's not in line with that. Or can you really wear that if you're Islamic? And I'm like, stop wading into it. If they say they believe it, just believe it. And you're dealing with the accommodation aspect, that if they request accommodations, and you're dealing with addressing sort of the offensive conduct or the disruption that arises from the workplace with employees talking about their belief system.
Right. Yeah, you mentioned a lot of things there that just trigger memories. Like you mentioned Catholic churches, like in Pottstown, Pennsylvania, where my wife's family's from, a lot of Catholic churches, but each Catholic church is different. There's Italian, there's Greek, there's Polish, Hungarian.
Absolutely. Yeah. See, there's your intersectional discrimination. If we're going to go for full circle, right? This idea that, maybe an employee could say, hey, even though I'm Catholic, I'm being discriminated against because I'm, Hungarian Catholic and not Roman Catholic or something.
Yeah. My brother went through a Buddhist phase, and he was in Columbus, Ohio, which you don't think about Buddhists in Columbus, Ohio, but there they are, and there were oh my gosh. He said there were different groups. There were the Zen Buddhists, there were Tibetan Buddhists. There were different types of Buddhists. And, to settle their differences, they had softball teams. So I don't know. There's just something spiritual about your softball self.
That is.
Out there.
Well, that's much better than war, which is historically many ways that religions settle their differences in some concepts. I hope I didn't just lose all your audience from that one. You can cut that out if you need to.
No. I think we need to wake everybody up. But but it's funny that's a very Ohio resolution to a dispute. Play softball.
Let's play softball. Yeah.
Yeah. He's out. Is he spiritually out, or is it just his body?
Yeah.
His physical self, and he's out, but he can come back. So later, you're not dead. Never mind. Okay. We're going to lose the Buddhist crowd. I'm a big fan of the beliefs. So I think that's everything. We won't talk about. No, I'm not going to say what we won't talk about, because then I'll want to. But I think this has all been helpful, and I appreciate it very much. Thank you for doing this.
Yeah, of course. Thanks, Tom. I always appreciate you having me. So I'm sorry if we insulted most of your audience.
Well, no, I'd like to get some feedback from people.
Yeah, give me the good feedback. Give him the bad feedback. So.